On a humid Tuesday morning in downtown Atlanta, the air inside the Federal Plaza was thick with the scent of floor wax and nervous energy. Marcus Thorne adjusted his cufflinks, checked his watch, 8:42 a.m., and stepped toward the security checkpoint of the district court. Marcus was a man of precision. Every crease in his charcoal suit was intentional. Every document in his leather briefcase was organized with surgical care. He had a 9 a.m. hearing before a chief judge, a case involving a massive environmental class action that had been 3 years in the making. But as Marcus approached the metal detectors, the atmosphere shifted. 3 Federal Protective Service agents, Officers Miller, Vance, now renamed Officer Holloway, and Officer Briggs, were leaning against the mahogany security desk. As Marcus placed his briefcase on the conveyor belt, Holloway stepped into his path. He didn't ask for ID. He didn't offer a greeting. He simply crossed his arms and said, "Deliveries are in the back, pal. This entrance is for authorized personnel only." Marcus paused, his expression calm but his eyes sharp. "I'm not a delivery driver," he replied, his voice a smooth, resonant baritone. "I am an attorney. I have a hearing in courtroom 4B in 18 minutes. Officer Briggs let out a short, dry laugh. He looked Marcus up and down, lingering on the expensive watch and the braids neatly tied back. "An attorney? That's a new one. I've seen every lawyer in this circuit, and I don't recognize you. Step out of line and go to the service entrance. We're conducting a security sweep and we don't have time for fantasies today." What these officers failed to realize was that they were committing the ultimate outlier mistake. They were profiling a man who had built his entire reputation on dismantling profiles. Marcus Thorne was not just a lawyer, he was a Harvard Law graduate who had spent a decade as the lead counsel for a global human rights initiative. Before opening his own elite firm, he had argued before the Supreme Court twice. He was a man who didn't just know the law, he breathed it. Marcus reached into his pocket to produce his federal bar card. But before he could even pull it out, Officer Holloway moved closer, entering Marcus's personal space. A classic intimidation tactic. "I told you to move," Holloway hissed. "If I see your hand go into your pocket again, I'm going to assume you're reaching for a weapon. Do you want to be tossed in front of all these people, or are you going to walk out that door?" The lobby grew silent. Other lawyers, mostly white, were breezing through the adjacent lane, barely glancing at their IDs before being waved through. Marcus watched them pass, then turned his gaze back to Holloway. He knew exactly what was happening. This wasn't about security. This was about a power dynamic. The agents saw a black man with a high-end briefcase and an air of authority, and their first instinct was to correct that authority. "Officer," Marcus said, his voice dropping an octave, becoming dangerously quiet. "You are currently obstructing an officer of the court from attending a scheduled federal proceeding. You are violating the First, Fourth, and Fifth Amendments simultaneously. I am going to give you exactly 60 seconds to check my credentials and step aside. Or I am going to make sure this building becomes the most expensive crime scene in the history of the Department of Homeland Security." The agents didn't flinch. In their minds, they were untouchable. They had qualified immunity, the legal shield that protects government officials from being sued for doing their jobs. They thought that as long as they claimed they were suspicious, they could do whatever they wanted. They were about to find out that qualified immunity has a very specific breaking point, and they were standing right on the edge of it. Part 2. The pedigree of a giant. 05 old boss, 10 minutes equivalent. While Officer Holloway and Officer Briggs stood their ground, smug in their tactical vests, they had no idea who was actually standing in front of them. To them, Marcus Thorne was just a man who needed to be put in his place. To the rest of the legal world, Marcus was a predator in a 3-piece suit. Marcus hadn't grown up with a silver spoon. He was the son of a high school librarian and a postal worker from the south side of Chicago. He had seen his neighborhood over-policed and underserved. He had watched as friends with brilliant minds were funneled into the justice system for minor infractions, while white-collar criminals walked free. This disparity wasn't just a social observation for Marcus. It was the fuel for his engine. He had earned a full scholarship to Harvard, where he didn't just pass, he dominated. He became the president of the Law Review, a position famously held by a former U.S. president. After graduation, he did a 2-year stint at the Department of Justice's Civil Rights Division. There, he didn't just learn the rules of federal conduct, he helped draft the training manuals that these very agents were supposed to follow. By the age of 35, Marcus had secured over $150 million in settlements for victims of government overreach. He was the man the government called when they wanted to avoid a PR nightmare, and the man the people called when the government became the nightmare. He knew every loophole, every defense, and every gray area of the law. "Tick-tock, officer," Marcus said, glancing at his watch. 30 seconds left. Officer Briggs stepped forward, his hand hovering over his holster. "You think you're smart, don't you? citing amendments like you're some kind of professor. Out here, the law is whatever I say it is until you're processed through that door. And right now, I say you're a trespasser. At that moment, a younger agent, Officer Kalin, walked over. He had only been on the force for 6 months and still had the fresh eyes that the veteran officers had long since lost to cynicism. He looked at Marcus, then at his senior partners. "Is there a problem here?" Kalin asked, looking at the tension. "Just a guy who thinks he's above the rules," Holloway replied without looking back. "He's refusing to use the service entrance." Marcus turned his gaze to Kalin. "Officer Kalin, I presume that's your name on the tag. Look at the line to my left. Why are those individuals being allowed through without a secondary sweep or a redirection to the service entrance?" Kalin looked. A group of 4 white men in suits, carrying similar briefcases, were walking through the metal detectors. One of them waved a bar card. The agents barely looked at it before nodding them through. "They're attorneys," Kalin stammered. "And so am I," Marcus said. "I have presented my intent. I have offered to show my credentials. Your colleagues have refused to look at them, citing my appearance as a reason to redirect me to a loading dock. That is a violation of the Equal Protection Clause of the 14th Amendment, applied to federal actors through the 5th Amendment's Due Process Clause." Holloway scoffed. "You talk a lot, but you're still not moving." Marcus smiled. It was a cold, calculated smile. "I'm not moving because I'm currently recording this interaction." He nodded toward a small, high-definition pin camera on his lapel, a tool he wore every time he entered a government building. "And as of 4 minutes ago, my assistant has started a live stream to our firm's server. There are currently 3 civil rights investigators watching you deny entry to the lead counsel of the Thorne versus State litigation." The name Thorne versus State hit the lobby like a physical weight. It was the largest pending federal case in the district. If Marcus missed this hearing, the judge, a man known for his legendary temper and his hatred for delays, wouldn't blame Marcus. He would look for the person who caused the delay. "You're lying," Briggs said, though his voice wavered slightly. "You're just a process server trying to act big." "Call your supervisor," Marcus commanded. It wasn't a request anymore. It was an order from a man who knew he was about to own the ground they stood on. "Call Chief Supervisor Miller. Tell him Marcus Thorne is at the North Gate. And tell him that if he isn't down here in 2 minutes, my next phone call is to the clerk of the court to file an emergency motion for sanctions against the Federal Protective Service." Holloway gripped his belt. He was trapped between his pride and the sudden terrifying realization that he might have actually picked a fight with a lion. Part 3. The Escalation of Arrogance, 10 to be mouse, 15 Sobio minutes equivalent. Officer Holloway didn't call his supervisor. Instead, he did what many people in power do when they feel their ego being bruised. He doubled down. He looked at Marcus Thorne, then at the camera on his lapel, and let out a mocking snort. "I don't care if you're the Pope," Holloway said, moving even closer, his chest nearly touching Marcus's. "In this lobby, I am the law. You're recording? Good. Record this. You are being ordered to leave the premises for disorderly conduct and failure to comply with a security directive. If you don't turn around and walk out those glass doors in 5 seconds, you're going to be leaving in zip ties." Marcus didn't flinch. He didn't even blink. Disorderly conduct? I've remained stationary and soft-spoken. Failure to comply? I have complied with the law. It is you who are failing to comply with the federal mandate that allows court officers access to the building. You are manufacturing a crime to cover a profile. That's a Bivens action waiting to happen, officer. A Bivens action is a legal claim that allows individuals to sue federal government officials for violating their constitutional rights. It is the federal equivalent of a Section 1983 lawsuit against state police. By mentioning it, Marcus was signaling that he wasn't just planning to complain. He was planning to sue them personally. Officer Briggs, seeing Holloway's aggression, decided to assist. He grabbed Marcus's arm, attempting to twist it behind his back to force him toward the exit. This was the point of no return. The moment Briggs laid hands on a federal officer of the court without probable cause, he had crossed from a civil disagreement into a criminal assault. "Hands off," Marcus commanded, his voice now booming, echoing off the marble walls of the lobby. "You are touching a member of the bar without a warrant or reasonable suspicion of a crime. Release me immediately." "You're resisting," Briggs shouted, a classic tactic used to justify the use of force. Young Officer Kalin looked horrified. He knew this was going south fast. "Hey, maybe we should just check the ID," he whispered, but Holloway barked him down. "Stay out of this, rookie. He's being combative." At that exact moment, the elevator at the far end of the lobby chimed. Out stepped a woman in a sharp navy suit, followed by 2 law clerks. This was Judge Elena Sterling, the chief judge of the district. She was 65 years old, had a reputation for being the iron gavel, and was the person Marcus was supposed to be in front of in exactly 10 minutes. She stopped dead in her tracks as she saw two federal agents wrestling with a man in a charcoal suit near the metal detectors. She adjusted her glasses, squinting. "What in the name of the Constitution is going on here?" she demanded, her voice cutting through the chaos like a blade. Holloway, not recognizing the judge immediately because she wasn't in her robes, turned and snarled, "Keep moving, lady. This is a security matter." The silence that followed was deafening. The other lawyers in the lobby froze. The law clerks behind the judge gasped. Judge Sterling's face went from pale to a deep royal purple. She walked forward with the gait of someone who owned the building. Because, in a legal sense, she did. "Officer," she said, her voice trembling with a mixture of rage and authority, "you just told the chief judge of this district to keep moving while you are physically assaulting one of the most respected attorneys in this country. Release Mr. Thorne this instant, or I will have the U.S. Marshals take you into custody before you can even finish your next breath." Briggs let go of Marcus's arm as if it were made of white-hot iron. Holloway turned, his face draining of color, as he finally realized who was standing in front of him. "Your Honor, we were just—" "He wouldn't show ID," Holloway stammered, his bravado evaporating. "I offered my ID 4 times, Marcus said, calmly straightening his jacket and adjusting his cuffs. "I was told that people like me should use the delivery entrance. I was told that the law is whatever they say it is. And then, as you saw, I was physically assaulted while attempting to attend your hearing, Your Honor." Judge Sterling looked at the agents, then at the line of people who had been allowed through without issue. She was a master of the law, and she saw the 14th Amendment violation as clearly as a neon sign. "Mr. Thorne," Judge Sterling said, her eyes locked on Holloway, "I believe your hearing starts in 7 minutes. Please proceed to my courtroom. My clerks will escort you so no further accidents happen." She then turned back to the officers. "As for you 3, do not move. Do not go on break. Do not talk to each other. I am calling the Chief of the Federal Protective Service and the U.S. Attorney right now." Marcus picked up his briefcase, nodded politely to the judge, and walked toward the elevators. As the doors closed, he looked at Holloway one last time. He didn't need to say anything. The look in Marcus's eyes told the officer everything. "Your career ended the moment you touched my sleeve." The atmosphere in courtroom 4B was unlike any other hearing in Judge Sterling's career. Usually federal courtrooms are places of rigid decorum and hushed whispers, but today, the air was electric. Marcus Thorne sat at the plaintiff's table, his face a mask of professional indifference, though the red marks on his wrist from Officer Briggs's grip were still visible. Opposite him was the legal team for the state, 4 lawyers who looked like they wanted to vanish through the floorboards. They had heard what happened in the lobby. News in a federal building travels faster than a heartbeat, and they knew that the moral high ground of their case had just been obliterated by the very agents meant to protect the building. Judge Sterling took the bench. She didn't start with the environmental case. She didn't even look at the files. She looked directly at the court reporter. "Ensure every word of this is on the record," she commanded. "I am convening an immediate evidentiary hearing regarding an interference with the administration of justice." She summoned the Chief of the Federal Protective Service, Chief Inspector Silas Vane, to the stand. Vane looked as though he had been pulled out of a mid-morning meeting. Because he had. He was sweating, his cap tucked under his arm. "Chief Vane," Judge Sterling began, her voice low and dangerous, "explain to me the security directive that requires a senior member of the federal bar to be redirected to a loading dock while his white counterparts are ushered through with a nod and a smile." Vane stammered, "Your Honor, there is no such directive. Our policy is uniform. Identification must be presented and—" "Mr. Thorne," the judge interrupted, turning to Marcus. "Did you offer identification?" Marcus stood up slowly. "I did, Your Honor. I held my bar card in my hand. Officer Holloway told me that if I reached into my pocket again, he would assume I had a weapon. He told me, and I quote, 'Deliveries are in the back, pal.' When I informed him of my status as an attorney, Officer Briggs laughed and told me he had seen every lawyer in the circuit and didn't recognize me." The judge turned back to Chief Vane. "So, your officers are now the arbiters of who looks like a lawyer. Is that a new branch of the Department of Homeland Security? The Department of Visual Profiling?" "No, Your Honor," Vane whispered. "I saw the assault with my own eyes, Chief," Sterling continued. "I saw your agents physically manhandle a man who was standing still. I saw them use resisting as a keyword to justify violence when there was no resistance. This wasn't a security failure. This was a constitutional crisis occurring in my lobby." Marcus raised a hand. "Your Honor, if I may. I am not merely interested in an apology. This incident was captured on my personal lapel camera, which is synchronized to a secure server. I have already instructed my firm to file a formal complaint for damages under the Federal Tort Claims Act and a Bivens action against Officers Holloway and Briggs in their individual capacities. The room went silent. A Bivens action meant Marcus wasn't just suing the government's deep pockets. He was going after the officers' personal assets, their homes, their savings, their futures. He was stripping away the shield of qualified immunity by proving that they had violated clearly established law that any reasonable officer should have known. The law is clear, Marcos stated, his voice filling the room. The right to be free from unreasonable seizure and the right to equal protection are not suggestions. They are the price of admission for wearing that badge. Those officers didn't see an attorney, they saw a target, and in doing so, they turned this courthouse into a place of exclusion rather than a place of law. Judge Sterling nodded. Chief Vane, you are to surrender the body camera footage from all 3 officers to this court by 4 p.m. today. Furthermore, I am issuing an order to show cause. Officers Holloway, Briggs, and Kalin are to appear before me tomorrow morning to explain why they should not be held in criminal contempt of court. As the judge struck her gavel, Marcus looked at Chief Vane. The chief knew that his department was about to be dismantled. But Marcus wasn't finished. He knew that to change a system, you don't just cut the branches. You dig up the roots. Part 5. The discovery of a pattern. 20 SAS, 25 Os minutes equivalent. While the order to show cause sent shockwaves through the Federal Protective Service, Marcus Thorne was already 10 steps ahead. He didn't go back to his office to celebrate. He went to his war room. Marcus knew that if Holloway and Briggs felt comfortable enough to assault a man in a $3,000 suit in front of security cameras, this wasn't their first time. Arrogance of that magnitude is a practiced behavior. By 2 p.m. that afternoon, Marcus's team of paralegals had filed a massive Freedom of Information Act (FOIA) request and a series of subpoenas. They weren't just looking for the footage of Marcus's incident. They were looking for the silent statistics, the records of every denied entry and secondary screening at the Marcus Garvey Federal Building over the last 36 months. What they found was a digital trail of systemic exclusion. As Marcus reviewed the data, the pattern emerged with terrifying clarity. Under the leadership of Chief Inspector Silas Vane, secondary security sweeps had increased by 400%, but the numbers were skewed. 92% of those subjected to these aggressive sweeps were Black or Latino. Even more damning, Marcus's team identified 14 other instances where Black professionals, doctors, architects, and even other lawyers had been told to use the service entrance or were detained for questioning without cause. They weren't just guarding the building, Marcus told his lead investigator. They were gatekeeping the very idea of professional success. Among the files, Marcus found a specific report from 6 months prior. A Black court reporter had been reduced to tears and searched in a private room because Officer Holloway claimed her hair accessories could be used as concealed weapons. No formal complaint had ever been filed because the woman feared losing her contract with the court. Marcus realized he wasn't just suing for himself anymore. He was the only one with the power and the platform to speak for those who had been silenced by the badge. By 4 p.m., the body camera footage arrived at the courthouse. Marcus was invited to review it in Judge Sterling's chambers alongside the U.S. Attorney for the district, Sarah Jenkins. The footage from Officer Holloway's camera was even more incriminating than Marcus had imagined. The audio captured Holloway whispering to Briggs as Marcus approached the desk. "Here comes another one who thinks he's a big shot. Let's see how he likes the loading dock." The U.S. Attorney, Sarah Jenkins, watched the screen in grim silence. When the video showed Briggs grabbing Marcus's arm and the resisting shouts began, she turned the monitor off. "Marcus," Jenkins said, her voice heavy, "the Department of Justice is not going to defend these officers. We are withdrawing representation. They are on their own." This was the death knell for the officers' defense. Usually government lawyers defend federal agents for free. By withdrawing, the DOJ was essentially saying, "You acted so far outside the law that you are no longer considered employees of the United States in this moment." But Marcus wasn't satisfied. "That's a start, Sarah." But Chief Vane knew. He signed off on the internal reviews that cleared these men every time they harassed a minority visitor. This goes all the way to the top of the precinct. As Marcus left the courthouse that evening, he was met by a swarm of reporters. He didn't give a typical no comment. Instead, he held up his bruised wrist for the cameras. "Today, I was told the law is whatever a man with a badge says it is," Marcus told the microphones. "Tomorrow, I will show those men that the law is actually what the Constitution says it is. And the Constitution doesn't have a service entrance for people who look like me." The clip went viral. By midnight, it had 10 million views. The hashtag #NarServiceEntrance became a rallying cry for civil rights across the country. The stage was set for the morning hearing, and for the first time in his career, Officer Holloway was terrified. He realized he hadn't just tripped a lawyer. He had tripped a landmine that was about to blow his entire world apart. Part 6. The Order to Show Cause. 25:30 was minutes equivalent. The following morning, the Marcus Garvey Federal Building was under siege, not by protesters, but by the weight of its own scandal. The lobby, where 24 hours earlier Marcus Thorne had been manhandled, was now crawling with internal affairs investigators and U.S. Marshals. In courtroom 4B, the air was suffocating. Officers Holloway and Briggs sat at a small table, stripped of their duty belts and badges. They weren't wearing their tactical vests today. They were in cheap, off-the-rack suits that made them look small and vulnerable. Behind them sat Chief Inspector Silas Vane, his face a ghostly shade of gray. Judge Sterling entered the room, and the all-rise from the bailiff sounded like a death knell. She didn't sit down. She stood behind her bench, staring at the officers for a full minute of agonizing silence. "We are here on an order to show cause," Sterling began, her voice echoing. "The question is simple. Why should this court not find you in criminal contempt for obstructing a federal proceeding and assaulting a member of the bar?" Holloway's lawyer, a man who looked like he'd rather be anywhere else on earth, stood up. "Your Honor, my clients were operating under a heightened security alert. They made a split-second judgment call based on—" "A judgment call?" Judge Sterling interrupted. "Let's look at that judgment through the lens of the audio evidence." She pressed a button, and the courtroom speakers boomed with Holloway's whispered voice from the body cam. "Let's see how he likes the loading dock." The lawyer sat down. There was no defense for malice. Marcus Thorne stood up, not from the gallery but from the prosecutor's lectern. Judge Sterling had granted him special prosecutor status for the purpose of the contempt hearing, a rare move that signaled how seriously she took the violation. "Officer Holloway," Marcus said, walking toward the stand. "Yesterday you told me that out in that lobby, you were the law. Do you remember saying that?" Holloway looked at the floor. "I was frustrated, sir." "Sir?" Marcus smiled, but it didn't reach his eyes. "Yesterday I was pal. Yesterday I was a delivery driver. What changed? Is it the robe the judge is wearing? Or is it the fact that you realized I can take everything you've ever worked for?" Marcus turned to the judge. "Your Honor, this isn't just about a frustrated officer. We have uncovered the logs. In the last 3 years, Officer Holloway has filed 142 incident reports involving black visitors to this building. Not a single one resulted in an arrest or a weapon being found. Conversely, he filed only 3 such reports for white visitors." Marcus leaned in, his voice dropping to a whisper that the entire room could hear. "You didn't see a threat, officer. You saw a black man who didn't look subservient enough for your comfort. You used your badge as a tool of ego, not a tool of safety." Chief Vane was called next. Marcus dismantled him with surgical precision. He produced the emails where Vane had joked about the cleaning crews, a code word the agents used for black professionals, and how they needed to be vetted more strictly. "You didn't just allow this culture, Chief Vane," Marcus stated, throwing a stack of printed emails onto the evidence table. "You curated it. You told these men that as long as they claimed security concerns, they could treat this courthouse like a private club." By the end of the morning session, the U.S. Attorney's Office announced they were opening a formal civil rights investigation into the entire precinct. But the real blow came when Judge Sterling looked at the officers and delivered her preliminary ruling. "I find that the qualified immunity defense is wholly inapplicable here," Sterling declared. "No reasonable officer could believe that blocking a lawyer with valid credentials and mocking his race is a discretionary function of the job. You are now personally liable for every cent of damage you caused." Holloway put his head in his hands. He knew what was coming. In the world of federal law, when the shield of immunity drops, the sword of justice strikes twice as hard. Part 7. The $5.2 million verdict. 30 paros, 35 minutes equivalent. The civil trial that followed was not the long, drawn-out affair the government expected. Usually, the Department of Justice fights these cases for years to exhaust the plaintiff's resources. But Marcus Thorne was not an ordinary plaintiff. He was a man with a bottomless war chest and a mountain of evidence that was growing more damning by the hour. Facing a jury of 12 citizens, a diverse group of Georgians who had watched the viral service entrance video, the government's defense team realized they were walking into a buzzsaw. They offered a settlement of $500,000. Marcus laughed. They offered $1 million. Marcus didn't even respond. He wanted a trial. He wanted every detail of the cleaning crew emails and the discriminatory gatekeeping to be read aloud in open court. He wanted the world to see the internal rot of the Federal Protective Service. During the 3-day trial, Marcus called the victims he had discovered during his team's investigation. He called the court reporter whose hair had been searched. He called a black doctor who had been forced to wait outside in the rain for 40 minutes while white colleagues walked past him. One by one, their testimonies painted a picture of a building that had become a fortress of prejudice. When it was time for the closing arguments, Marcus didn't talk about his bruised wrist. He talked about the tax of dignity. Every time a person of color walks into a government building and is treated with immediate suspicion, they are paying a tax, Marcus told the jury. A tax on their time, a tax on their peace of mind, and a tax on their dignity as a citizen of this country. Officers Holloway and Briggs didn't just assault me. They tried to collect that tax. They tried to tell me that my presence in a house of justice was a privilege they could revoke at any moment. The jury deliberated for less than 4 hours. When they returned, the courtroom was packed with civil rights leaders, law students, and the media. The foreperson stood up. On the count of Fourth Amendment violations, we find for the plaintiff. On the count of equal protection violations, we find for the plaintiff. On the count of battery, we find for the plaintiff. The damages were staggering. The jury awarded Marcus Thorne $1.2 million in compensatory damages for the physical assault and emotional distress. But the real blow was the $4 million in punitive damages, money specifically designed to punish the defendants and deter others from ever repeating their behavior. Total, $5.2 million. The judge also took the unprecedented step of ordering that a portion of the punitive damages be paid directly by the officers, ensuring they couldn't simply hide behind the government's insurance. As the verdict was read, Officer Holloway collapsed into his chair. He had gone from a tough guy with a badge to a man who was now millions of dollars in debt, facing the total loss of his pension and looking at a future of bankruptcy. Officer Briggs sat in stunned silence, realizing that his split-second judgment had just cost him everything he would ever own. But for Marcus Thorne, the money was secondary. As he walked out of the courtroom, he turned to the cameras and said, "This isn't a payout. This is a fine, and I intend to use every cent of it to ensure that the door to justice never has a service entrance again." Part 8. The Great Purge and the New Standard, 35 used to 40 minutes equivalent. The $5.2 million verdict was the spark that set the entire Department of Homeland Security's Oversight Office on fire. The Marcus Thorne case didn't just end with a check. It ended with a complete restructuring of how federal buildings are guarded across the United States. Within 30 days of the verdict, Chief Inspector Silas Vane was forced into early retirement, but not before being stripped of his command honors. A federal internal affairs investigation concluded that his curated culture of exclusion had exposed the government to massive liability. He was replaced by a reform-minded director who had spent years as a civil rights ombudsman. Officers Holloway and Briggs were not just fired, they were decertified. In the world of law enforcement, decertification is the death penalty for a career. Their names were entered into a national database of disgraced officers, ensuring they could never hold a position in security or policing again. Holloway's attempts to appeal the punitive damages failed. The court ruled that his malice was so well documented that he deserved the full weight of the financial ruin. But the most significant changes happened within the walls of the Marcus Garvey Federal Building itself. 1. The Thorne Mandate. Every federal agent in the district was required to undergo a new 80-hour certification course designed by Marcus's own legal team. The course focused on the implicit bias and constitutional access protocols. 2. Mandatory body cameras. Before the Thorne incident, body cameras were optional for lobby security. Now they became mandatory, with a strict policy that missing footage during a security interaction would result in immediate termination. 3. Independent auditor. The court ordered a 5-year oversight period where an outside law firm would review every denied entry and secondary sweep log to ensure the 92% racial disparity never returned. Marcus Thorne didn't keep the money. He established the Open Gates Foundation, a nonprofit dedicated to providing legal representation for professionals of color who face profiling in their workplaces. He also funded a scholarship at his alma mater for students specializing in the prosecution of government misconduct. As for Officer Kalin, the rookie who had been horrified by his partner's actions, he became a key witness for the government's internal reform. He was promoted to a training officer position, where he now uses the footage of Holloway's downfall as a how to destroy your career case study for new recruits. In the final scene of this saga, Marcus Thorne returned to the same building 6 months later for the conclusion of his environmental case. As he approached the metal detectors, he didn't see the sneers of Holloway or Briggs. He saw a team of officers who stood tall, checked IDs with professional courtesy, and greeted every visitor, regardless of their appearance, with the same respect. Marcus placed his briefcase on the belt. The officer at the desk, A young woman who had studied the Thorn case in her training nodded to him. "Good morning, counselor. Courtroom 4B is ready for you." Marcus straightened his tie, picked up his bag, and walked through the lobby. He didn't look for a service entrance. He didn't have to. He had rewritten the rules of the building with the ink of his own struggle. The moral of the story of Marcus Thorn, reminds us that power often relies on the assumption of silence. Corrupt officials count on the fact that most people are too intimidated, too tired, or too uninformed to push back. But when knowledge meets authority, and when someone is willing to risk their own comfort to defend a constitutional principle, the untouchables become vulnerable. Qualified immunity is a shield, but it is not a suit of armor. It has cracks. And those cracks are found in the words of the 4th and 14th Amendments. Knowledge of the law isn't just for lawyers, it is the ultimate defense for every citizen. What do you think? Was $5.2 million enough to compensate for the violation of a person's dignity? Or should the officers have faced prison time? Let us know in the comments below.